Hello students, welcome to Professor Reena Lenka's channel. Today we would be starting with another new topic on business law, that is the Negotiable Instruments Act 1881. So before we proceed further, I would again like to remind you, in case of any queries or suggestion, please leave your comments in the comment box. Okay, so let's start with the topic. So this act, that is the Negotiable and Instrument Act, it is the law relating to negotiable instruments. The law relating to negotiable instruments is contained in the Negotiable Instrument Act 1881, which applies and extends to the whole of India. So it's basically throughout India. Okay. So what do you mean by negotiable? The word negotiable means transferable by delivery, and instrument means a written document by which a right is created in favor of some person or persons. So the word negotiable means like you are transferring your right to another person, and the instrument or the document through which you are transferring, it should be a written document. So the entire thing is known as negotiable instrument. Means the document, a written document, which gives the right to another person to get certain amount of money or certain amount of, it's basically regarding money matter. Okay. So this is known as a Negotiable Instrument Act. So thus the term negotiable instrument literally means a written document which creates a right in favor of somebody and is freely transferable. So it is giving you a favor, it is giving you a right to do business with someone, at the same time get the money related to the business, and this is transferable. Means if I am giving you a check, means I am giving you the right from my end. So I am transferring my right to you to receive the money which is due to you. So this is the meaning of a negotiable instrument. Okay, so let's proceed further. A negotiable instrument is a piece of paper which entitles a person to a certain sum of money and which is transferable from one to another person by a delivery or by endorsement and delivery. So it's basically, like I've told you, it is a piece of paper which is entitling, means which is giving the right to another person to get certain amount of money which is due from the person who is giving you this instrument, negotiable instrument. Now negotiable instruments are of different types. For example, we have promissory note. So students, you must be knowing what is the meaning of a promissory note, or you must have heard about the same. So promissory note basically is a written document where a promise is made from one person to another that on so and so date, this amount of money, say 1 lakh of rupees or 2 lakhs of rupees, would be given to the other person to whom this promissory note is handed over. Okay, then check students, you must have seen a check, and you must be knowing that through check also we are trying to give money to the other person which is due from the other end from us. A bill of exchange, again a bill of exchange is another instrument where in respect of that bill you are getting that money. Documents such as railway or receipts or dividends, warrants, all these things are a negotiable instrument, because through this you are giving a right to the other person to redeem the money which is actually due for him. Okay. So the characteristics of negotiable instruments, let's go ahead with this. So the first characteristics is it is freely transferable, or e.g. negotiability. Means it's freely transferable means you can, means one person can freely transfer the right of that particular instrument to another person. For example, say if like I and my friend, okay, suppose I have taken a cell phone from my friend, okay, and I am supposed to pay say 20,000 rupees for the cell phone. right? So that 20,000 rupees I have to pay to my friend. So instead of cash, what I do is I give a check. Now this check is a document which is a part of a negotiable instrument. In the check, I put the money, that is 20,000 of rupees, and I sign my check and give it to my friend. So what I'm doing is, this check is mine. I have an account in a particular bank. Suppose this check belongs to HDFC Bank, right? So this check is in HDFC Bank, and this right I am giving to the other person to deposit that check in HDFC Bank or any other bank and get the money, that 20,000 rupees which I was supposed to pay to that person. So it's basically a transfer of right to another person to redeem the amount of money which is due to the other person. Okay, I hope students, you are understanding this. Next we go to another characteristics, that is title of holder is free from all defects. Holder means who? Holder is the person who has the right for that particular negotiable instrument. A person who takes negotiable instrument bona fide and for value gets the instrument free from all defects in the title. The holder in due course is not affected by defective title of the transferor or any other party. Now, for example, a holder here would be like, suppose, for example, if you say that I have, given, say, check or a check of, say, 10,000 rupees, okay, to one of my client, okay, and suppose that 10,000 rupees is not in my bank, but still I give a check, right? So here the person who is holding, means the check which I have given to my friend, now he becomes the holder because I have given that right. I have transferred my right from my check to my friend's check. Okay, so now when the check is being given to my friend, so that my friend check has got no defect because it's been given from a person who has got a account. Now anything goes wrong with the check, if the check is bounced or the check if the check is bounced or anything happens with the check, so my friend is not at all liable for the same. It would be I as a transferor who would be liable for any kind of defects. The check which I have given, it is free from any defects. At any moment of time, my friend can deposit the check and can get the money. So this is the meaning of title of holder is free from all defects. The person who is giving, the transferor, would be liable for any kind of defect, but the person, the holder to whom the check has been given or the promissory note has been given or a bank draft has been given or a pay order has been given, these kind of things is free of defects for the person who is holding that. I hope it is clear, students. So now let's go to other things. There is a presumption. What do you mean by presumption? That, presumption means whatever you are thinking or, deciding, right? So presumption of consideration, that every negotiable instrument was made or drawn for consideration. So basically you are presuming as a holder or a person who would be getting the right that any kind of negotiable instrument is being drawn or has been given to the holder to take care of the money which that person would be getting. So this is a consideration, that it has been drawn in such a way that the holder of the Instrument Act would be getting the money. As to date, that every negotiable instrument bearing a date was made for drawn on such date. So you must have seen the check or you must have seen a promissory note or anything. Date is mentioned. In case of a check, it is valid for 3 months, 6 months, right? And in case of a promissory note, a date of say 1 month or anything is given. So the date which is mentioned there, so it is presumed that it is till that date that instrument is valid. exchange was accepted within a reasonable time after its date and before its maturity. So, see, I am giving a check, or I am giving a promissory note, or I am giving a bank draft. So, the acceptance by the holder has to be done within a reasonable time. Like I said, if a check is valid for say 3 months or 6 months, now that has been accepted. Now, until unless I deposit within 6 months or 3 months, that check is of no use. If I deposit after 3 months or 6 months, it is of no use, right? So, here the condition is that any kind of bill of exchange which is accepted, it should be accepted within a reasonable time and before the expiry date of that particular bill of exchange. If it is for 1 month, the bill of exchange should be encashed within 1 month. If the check is for 3 months or 6 months, it should be encashed within 3 to 6 months. After that, it becomes null and void. So this is the meaning of a time of acceptance. So any kind of negotiable instrument should be accepted within a reasonable time. As to time of endorsement, that the endorsement appearing up to negotiable instrument were made in the order in which they appear thereupon. Endorsement means what? Endorsement means whatever is, the signature, the amount, all these are endorsements. Okay, whatever is written in the promissory note or bank draft or check are all endorsement, means it is legally viable. Okay, so the endorsement appearing up to negotiable instrument were made in the order which they appeared thereupon. So whatever terms and conditions were there when this negotiable instrument was drawn, so that when the other person is giving you, the same terms and conditions should have been put. Okay, fine. As to stamps, that a last promissory note, bill of exchange or check was duly stamped. So obviously when you are getting a legal thing, it has to be stamped by the organization. In case of a check, the name of the person, the person who is having an account in the bank, his or her name is there, the name of the bank is there, it is already made stamped. I mean, it's already done in such a way that that check is already legal. In case of promissory note, stamp of the company has to be put. In case of bank draft also, company, see, the bank has to give when they're accepting it, they're giving you a stamp. They would be stamping it and giving you the receipt that yes, on so and so day your check or bank draft or anything has been done. So the stamp is very necessary because this is a proof that that particular negotiable instrument has been deposited on so and so date. It's a proof, right? As to a holder in due course, that every holder of a negotiable instrument is holder in due course. Holder in due course means that you become a holder when a person is transferring that bill of exchange from his name to the other person's name. The other person who's holding that particular negotiable instrument, promissory note, check, bank draft, and bill of lading, all these things, so that person becomes a holder. And the time frame within which this promissory note has been given. So within that, from the day I am supposed to, pay 20,000 rupees to my friend. From the day I hand over the check to my friend, my friend becomes a holder of that particular check which I have given in due course. Means from that time onwards till the maturity date, my friend becomes the holder. So this is the meaning of holder in due course. As a time of transfer, that every transfer of a negotiable instrument was made before its maturity. So the validity of a particular document has to be seen and the instrument has to be encashed within that particular time frame. If it is done, then that negotiable instrument can be said that it has been made within a time of transfer. Okay. So for students, let us go to the types of negotiable instrument. So negotiable instruments are basically two types. Okay, so negotiable instruments which is recognized by status. There is a status to that. If you're getting a check, there is a status of the check that yes, I have got a check and this is my negotiable instrument. Promissory notes, again, it is a status that a person has promised the other person to pay that amount of money, 2 lakhs, 3 lakhs, 1 crore within a specific period of time. Bill of exchange, again I have explained, like these things are a status. Okay, negotiable instrument recognized by uses or custom of trade. If it is related to a business or it is the document is related to a particular type of business, so that is known as negotiable instrument recognized by uses or custom of trade. Example, bank notes. You must have seen a bank note, a note coming from the bank that on that so and so within so and so date the this person would be given so and so amount of money. Exchequer bills. Exchequer bills are the bills which are also given from a company, and this is again more or less like a promissory note. Share warrants. This I have already explained in my previous video in the Companies Act, where I was discussing regarding the share warrants. So share warrants are nothing but a document or a certificate that so and so person is having so and so share from the company. So this is a kind of a by uses. So this gives you a guarantee for the dividend, right? Bearer debentures. So debentures, students, you must be knowing, it's more or less like a share, but it is a more or less like a loan type. Share, the shareholder is giving money and for to become owner of a particular part of the company. Debenture, when a company is in need of money, is in need of loan, can give the document and can get loan, and this is for future project generally, and can get the loan in lieu of this particular document. Dividend warrant, like when you are paying the dividend against the share which the person has already purchased, the shareholder is purchased. So that is again a kind of a document which says that this person is entitled for this much dividend. Share certificate, it is a proof that a particular person, if suppose I am a shareholder, it is a particular proof, and I suppose I am a shareholder and I have purchased 100 shares for Reliance, right? So the Reliance would be issuing me a share certificate where the date would be given, the name of the person, that is me, would be given, and then how many share I have purchased. Suppose it is 100 shares. The share value for each share is say 100 rupees. So I would be stated that okay, I have taken, this person has taken 100 share, the face value is 100 rupees, and this is the amount of money this person has paid, and this is share belongs to this person. So this is the meaning of share certificate. Okay, so students, let us proceed further. Bill of exchange. Let us understand what bill of exchange is all about. A bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to the order of a certain person or to the bearer of the instrument. Basically, it's a promise. It is a kind of an order given by one person in writing that, and also signed by that person. Today, if I am giving a bill of exchange to my friend, so I have to write that I have to sign it, and then I have to give a direction to another of my friend or colleague that should be given to the bearer of this bill of exchange. Okay, so for example, Mr. Y buy goods from Mr. S for rupees 1000, then Mr. Y may order Mr. X to pay rupees 1000. Mr. S, which will be nothing but a bill of exchange. So in this case, students, here what happened is X is purchasing certain goods. Like for example, say X is purchasing 1 kg mango for rupees 100, and X is purchasing from Y, who is the shopkeeper, for rupees 1000. At the same time, Y is also purchasing mango 1000 rupees from another shopkeeper, that is Mr. S, for rupees 1000. So what happens is, instead of Mr. Y paying money to X, Mr. Y directs Mr. S, that is the shopkeeper, that yes, what you do is you need not what you do is you give 1000 rupees to Mr. X and I'll give you 1000 rupees back. So this is a bill of exchange. Okay, promissory note, it is again a promise. It's an instrument in writing containing an unconditional undertaking signed by the maker to pay a certain sum of money only or to the order of a certain person or the bearer of the instrument. So it's basically a promise made by one person. Generally, students, what happens, promissory notes happen when, suppose you being in a company and a company has ordered, say around 100 pieces of computers or 200 pieces of computers, and at that time the company hasn't paid the entire sum of money. Suppose each computer is costing, say 10,000, 20,000 rupees, okay, 20,000 rupees, say, and 100 computers are there. So at that moment, money hasn't been rendered to the vendor. Okay, some portion of the money is left, or say 10% money has been paid and 90% has been not paid. So that sum of money can be taken as a credit from the vendor, and a promise, a document would be given by the owner of the company or the director of the company. Suppose I am the owner of that company, so I would be giving a promissory note, okay, where the name of the person to whom I am supposed to give the money would be written, and it would be signed by me. The date would be given, sum of money, how much I have to render, and on which date I have to pay. So either I pay, or if I am in a higher position, I can order my subordinate to pay the vendor on so and so date. So this is the meaning of a promissory note. Okay, so this is a specimen of a promissory note. So here, see, the sum of money has been written, then on which date, okay, it has been drawn. Then it has been written like this: 3 months after the date, I promise to pay Mr. X of Mumbai or order a sum of rupees 50,000 for value received. So to the address and stamp and signature of Mr. Y. So this is a promissory of a specimen of a promissory note, where the amount is written, the date has been written, the sum of money has been written, and on which day or months the money would be rendered, that would be written, address of the person to whom I am paying, that would be written, and the signature of the stamp and signature after the receiving of the money. So that would be that has to be done by the maker. If I am giving, so my stamp and signature would be there. Okay. Now, what are the characteristics of a promissory note? It is a negotiable instrument. Obviously, it is through this instrument only I would be able to get certain amount of money which is pending, or which I am which I would be getting, right? If I am doing a business, this is the amount of money which is due to me. So this is a negotiable instrument because through this only the business is being conducted. At the same time, the right to get the money is also being transferred from one person to another. It must be in writing. It cannot be a oral form. It would be in writing. It is a promise to pay money only. So promissory note or any kind of negotiable instrument is related only to money. Any other thing, we cannot take this as a promissory note. It must be definite, means a definite sum of money has to be there, and the promise to pay must be also definite, means there shouldn't be that today I am giving a promissory note to my friend stating that I would be paying you 1 lakh of rupees after I would be paying you 1 lakh of rupees without mentioning the date or anything. So this cannot be a promissory note because a specific date has to be mentioned, a specific amount of money has to be mentioned, everything should be definite. It must be unconditional, undertaking to pay must be unconditional. So it should be unconditional, means there I cannot negotiate. My friend has given me a computer, say for 1 lakh of rupees, right? I am promising 1 lakh of rupees. I cannot write in the promissory note that I would be paying you 50,000 rupees. So this is unconditional, where I have to pay 1 lakh of rupees. I cannot negotiate with the amount of money which I am supposed to give to my friend. So it should be signed by the maker, which I have already explained. Maker of the promissory note must be a certain person and the payee must also be certain. So the promissory note, whoever is making, should be a particular person, and the person who would be collecting that money in lieu of the promissory note should be also the particular person to whom this promissory note has been given. Amount of the promissory note must be certain. Then number, date, place, everything should be certain. Promissory note must be properly stamped. Students, you must be knowing the importance of stamp. Stamp is a legal thing. If it is not stamped, then what happens is a person might say, right, that I haven't given you this promissory note, but if the stamp and date given and everything, it becomes a legal format. So if the person who has given the promissory note is not keeping his promise, the holder can take him to court. So stamp is very important, which gives you a proof, which is a legal formality and a proof that this particular note has been prepared by a person on so and so date. Okay, students, let's proceed to another of the bill of exchange, that is a check. A check is a bill of exchange drawn on a specified banker and expressed to be payable otherwise than on demand. So basically, students, you must be knowing the check is for a particular bank. If I have a account, I should be having an account and the check should be belonging to that particular bank where I have an account. Now, if I have an account in HDFC Bank and I don't have an account in, say, Bank of Baroda, and I want to give a check of Bank of Baroda, so it is not at all acceptable. Okay, so wherever you are drawing a check, it should be for a particular bank, right, and which you have an account in. Okay, and it gives right to that person to whom the check has been given to go to the bank and demand the money from that bank within a specific period of time. The maker of a bill of exchange or check is called the drawer. So if I am giving the check, means I become the drawer, and the person who is withdrawing money from that check would be a drawee. Now, what are the characteristics of a check? A check is a negotiable instrument, obviously. It is a bill of exchange because by giving that check and by getting money by depositing to the bank, what happens is the money is being transferred from my bank to the other person. So it is a bill of exchange. It is always drawn on a specified banker. It has to be a specified banker in which the drawer has a account. It's always payable on demand. Until unless you go and deposit the check in the bank is not going to come on its own to pay you the money. So it has to be on demand. Okay, a check can be bearer, order, or cross. It can be a bearer check. It can be a cross check. Students, you must have seen that in the check, in certain check, we just cross it on the top left hand side. Okay, what is the importance of cross check? Do you know that no one can that particular cross check would be only for that particular bank, right? If someone takes away that also, he or she cannot encash it anywhere else. So that is a cross check. Okay, then bearer check means where the money is already deposited and this check is being given, right? So that becomes a bearer check, order, or cross check. Okay, now a check requires no acceptance in the ordinary course of business as it is intended for immediate payment. So this is not required for any course of business, because obviously the check has to be deposited and money has to be taken. So it's a more or less like an immediate payment. In case of a check, a drawee is always a specified bank. Obviously it has to be for a particular bank where the account is there. A drawer is a person who draws a check and who has an account in the bank. So now the drawer who is drawing that particular check, the drawee is taking the particular check, so he or she has to be also has to have an account in a particular bank also, because without two people, the drawer and the drawee, having account in any particular bank, a check cannot be given to one another, right? And it cannot be encashed. So account should be there. Negotiation, basically it is a process of transferring the ownership, right, title, interest of a person in a negotiable instrument to another person, so as to give a good title to the transferee and make a transferee a holder of such instrument. So negotiation, basically, like I have been explaining to you, it is basically a transfer of ownership. Means a right has been transferred through the negotiable instrument in terms of check, in terms of pay order, in terms of promissory note. All these things are negotiable instrument, and here the right is being transferred from one person to another, to the holder who would be holding the instrument. Okay. Negotiation does not mean a simple transfer. Simple transfer may not necessarily involve the transfer of property. So negotiation is not a simple transfer. It is basically a transfer of ownership from one person to another. The right of demanding certain amount of money which is due is done through negotiation and negotiable instruments. Okay. For example, if I am handing over a check to my friend of rupees 2 lakhs of rupees. Okay. So here I am negotiating the instrument with my friend. Okay. But if I'm asking my friend to keep that check safe, then the check is not negotiated then the check is not negotiated with my friend, because my friend only becomes a caretaker of the check. I haven't given the right to my friend to go and encash the check. Okay. So here my friend would be only cannot be a holder. He would be only a caretaker or a bailee. So if I am giving a check to my friend and I'm not asking him anything to do, then my friend becomes the holder. If I'm asking my friend to keep the check for as a safe custody, then then my friend doesn't become a holder, he becomes a bailee. Okay. So what are the features of negotiation? There must be transfer of a negotiable instrument. Obviously, we are talking about a Negotiable Instrument Act. So negotiation has to be done, means right has to be transferred from one person to another. As a result of such transfer, the transferee must become the holder of the instrument. Okay. So when this transfer is being made, when the right is being transferred, so then what happens? The person to whom this instrument has been transferred, so that person becomes the holder of the instrument, means that person gains the right to demand for certain amount of money which is due to that holder. So that is the meaning of negotiation. Okay. So what are the modes of negotiation? Negotiation by delivery and negotiation by endorsement and delivery. Now let us see what negotiation by delivery is all about. The negotiable instrument is transferred by delivery, actual or constructive. It is physical act of delivering the instrument or handing over the delivery. Now what happens? It is by delivery. Now today, if I am giving a promissory note to one of my colleague, Okay, that I would be within a month or so, I would be giving my colleague, say, around 5,000 rupees. Okay, so this thing I need to hand it over to my colleague. So if when I'm handing it over this promissory note to my colleague, means that becomes a actual delivery or a physical delivery, and the instrument is in actual position, then that becomes a negotiation by delivery. Okay, negotiation by endorsement and delivery. The negotiable instrument payable to order is negotiable by the holder by endorsement and delivery thereof. So an endorsement has to be there, means the check, the amount should be there, the signature should be there, that the date should be there. So then it becomes a negotiable by endorsement, and then it becomes viable, and then it becomes legal. Okay, endorsement, literally meaning of the term endorsement is writing on an instrument, means you're writing something, you are an endorser, right? Means you're writing something. So endorser, the person who signs on the back or on the face of the instrument or on the sleeve, is an endorser, the person who is signing it. If it is my check, I sign it, I become the endorser. The person to whom this instrument is being given becomes a endorsee. Okay, so the person who has got the right to sign it becomes an endorser. The person for whom this thing has been done becomes an endorsee. Types of endorsement, we have general or blank endorsement. Endorser signs his name either on the back or face of the instrument. So here what happens, it's a general endorsement. So if students, you must have seen on the promissory note or a check signed on the front side or at the back. Sometimes if you go to the bank would be saying that you sign at the back of the check. So what happens, you write your account number and sign also, means if something goes wrong, then from the back side also you can see whose account it is, like when it has been deposited. So back or face, so this becomes a general endorsement, means the person has an account in the bank and the person is giving his right, is transferring his right from that promissory note to the other. Full or special endorsement, it specifies the name of the person to whom or to whose order the payment must be made. So if it is a specific endorsement, so here the name of the person has to be mentioned, the name of the person of whom, to whom we owe certain sum of money. So that becomes a full or special endorsement. So when we are signing it, if you see a check, on the top we are writing the name of the person to whom, name of the person or the company to whom we are giving. So that becomes a special endorsement. The signature which we are doing at the bottom or at the back, that becomes a general endorsement. Okay. Partial endorsement. Endorsement is made for remaining balance of payment. So like suppose sometimes it happens, students, that if you are purchasing a flat or you are purchasing a car, so at one time you are not able to pay the entire amount of money, so we give a check, 3 or 4 check, so that we go on writing the amount of money, so that becomes a partial endorsement. Okay, so again the same signature and everything is given, so that becomes a partial endorsement. Okay, so where it is not given, where the payment is not given at one time, where 2 or 3 times we are doing it and we are also signing it. Okay, so that becomes a partial endorsement. Conditional endorsement, the liability of the endorser is limited or negative. So conditional endorsement actually is not there. It is, the endorsement is totally unconditional, to whom I am giving amount of money, for whom I am giving the promissory note or check or anything. There the holder cannot come under any condition. The condition endorsement is limited or it is negative, so there is no need for putting any kind of condition. Only the amount of money, the date, the name of the person to whom we are giving, the name of the person, stamp, and date of that particular person who's drawing that particular negotiable instrument has to be mentioned. There cannot be any kind of condition for the liability of the endorser. Okay. Now, dishonor of negotiable instrument. Negotiable instrument, promissory notes and check may be dishonored by non-payment. So, students, you must be knowing that sometimes we give a check and it gets bounced in the bank because we don't have that much balance. So, the promissory note can also be dishonored. Checks may be also dishonored. So, there are certain things because we don't have the amount of money. It might so happen the day we had, given the check. The day we have given the check, at that time we were having certain amount of money, that amount of money in our bank, but after that we don't have. So then the account, the check becomes dishonored because the day the person, the holder goes and deposits, and it might happen that we don't have enough money in the bank. So bills of exchange may be dishonored by non-payment or by non-acceptance as they require acceptance from drawees. So bill of exchange can be dishonored because of non-payment, right? We are not paying it, so it can be non-acceptance if the person is not accepting, the bank is not accepting because there is less amount of money in the account. So then it becomes a dishonored. So students, today I end this chapter on Negotiable Instruments Act. It was a small chapter, no doubt, but there were certain things which needed to be understood. So again, I would repeat the same thing, that in case of any queries or suggestion, please do leave your comment in the comment box. At the same time, if you're really liking my video, please do subscribe to my channel and wait for other videos to come, because I would be coming out with much more other videos and other interesting topics. Sometimes students who might be thinking that my videos are long, but if you see the chapters which we are covering, that too within 1.5 hours or 2 hours, it is really very less time. Because each chapter of business law, if you see a Indian Contract Act or if you see a Companies Act, so these chapters are more than 200 pages if you go through the books. And it becomes very difficult to understand that also, because so much is written in that. It becomes very difficult for a student to go through each and everything. And that too during the exam time, when you students think of revising, it becomes a mammoth task for you. So the whole idea of creating these videos is that I can explain in a very simplified way which you can understand, and if you are going it through my videos before your exam time, so it would help you a lot, because you need not be confused, because I'm explaining it in a very simple way, and these videos are sufficient enough for you to understand and write in any exam, right? And so when there are videos of 2 hours or 1.5 hours, please be patient and listen to it, because this is going to help you. And it is also, you are also saved from going through so many pages. So that is my whole idea, that saving the students from going through so many pages before the exam, and a kind of a knowledge giving session where students do understand and can also write it in their own words if you are really understanding it. So students, bye for now. Keep a watch for other videos which would be coming. At the same time, like my video, please subscribe for my channel, and thank you so much for listening to me patiently. And bye for now, and stay safe, and God bless.